is Jarryd Atherly. He's a first-year law student, and he will be presenting on should the state revise the penal system as it relates to juvenile offenders. Let's welcome Jarryd to the stage.
Pleasant good morning to the Honorable Mr. Justice Ronnie Budusing, Professor Rosemary Bell Antoine, Dean of the Faculty of Law at the UE St. Augustine, and Ms. Miriam Samaru, Principal of the Hugh Law School. I have been assigned with the responsibility to inform you all as to why we should revise the penal system with regards to our juvenile offenders. As we all know, in Trinidad and Tobago, violence amongst teenagers has drastically increased, to the point where every week we see viral videos of students in uniform engaging in extremely violent fights, either on Facebook or on the news. This growing trend of bullying is one of the leading factors that steers our juveniles down a path of destruction and criminal activities. I will highlight the main defects in our current system, and then I will highlight some of the improvements to be made in order to deal with the problem instead of quietly allowing it to grow beyond our control. One of the defects is that our current system has a very traditional approach to punishment. This essentially results in you do the crime, you do the time. And we have juveniles being sentenced to the youth training center, where juveniles may be held until they are 18 years old. Under Section 44 of our Children's Act, if a parent proves to a magistrate that he is unable to control his child, he may request that the child be sent to an orphanage and simply become someone else's problem. These juveniles are sometimes also sent to St. Michael's Home for Boys, where they are still vulnerable to further abuse. Another example that shows the vindictive nature of our current system is the fact that we attempt to instill fear onto our offenders so that they would be deterred from criminal activity. It is this fear that led 16-year-old Marlon Aguilera to hang himself in the police holding bay of the family court in 2006. Why? Because after his conviction, he chose to kill himself rather than to spend any more time at the YTC. He chose to die rather than to be subjected to further sexual and physical abuse by prison officers, who would either bribe them with money to stay quiet, or those who defied them would be taken away and beaten separately. This constant sense of fear and survival is psychologically destroying our youth, and we need to repair the damage that we have caused. Another defect in our system is the fact that we do not have sufficient judicial facilities to deal with the matters of children. There has been a significant increase in the amount of children appearing before the courts. Just last year, 149 cases of serious crimes committed by children were reported. This, in effect, just added to the backlog of cases the court already has to deal with. The solution to this problem would be to establish a specialized juvenile court with rehabilitative systems put in place, specially designed for young offenders. This was suggested by the Honorable Chief Justice, Mr. Ivor Archie. What this specialized court seeks to do is to increase the ability of the judiciary to properly assess matters with young offenders, adopting a more liberal approach towards punishment, as we agreed to do earlier when we ratified the Convention on the Rights of the Child back in 1991. This is exactly what our penal system is crying for, because it would ensure that juvenile matters are dealt with in a more sensitive and efficient manner. Also, instead of using isolation and other socially damaging factors associated with custodial punishment, this project promotes juvenile offenders to be more involved with society with a vision to harness their true potential. This is not to say, as a nation, that we have been completely oblivious to the facts. Earlier this year, some very motivating decisions have been made by the courts that can potentially lead to the reform of the penal system that we have been awaiting. The Honorable Justice Kokaram granted lawyers the permission to challenge a juvenile's detention at the Youth Training Center as being unlawful and unconstitutional. This was the first time a successful petition had ever been made to the court's power to send minors on remand to facilities such as YTC. This is the mentality we need to encourage in the courts so that we can deal with this issue as a nation. It is very important to remember that most of the youth behind our juvenile systems are often those who have not had the opportunity under right guidance or mentoring around them due to disruptive homes or lack of parenting, bad influences, peer pressure. This does not mean that we should simply leave their fate to the harshness of the law and hope for the best. As Nelson Mandela once said, children are our greatest treasure. They are our future. Thank you.